facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand with grass speeding, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all four tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway. What was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said that 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness' tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed Water Creek, then climbed the fence attached to private residence. And fled on foot for approximately 0.4 miles before he was later detained by a Houston Police Department and turned over to deputies. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant had red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor, Your Honor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, knows this to be represented cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety tests. Those were administered and the officer observed success exclusion on the HGN. The officer did not administer the walking tour of the one-leg stand due to the defendant injuring his feet while fleeing. The defendant consented to a breath sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw for the defendant.
Okay. Your Honor, may I come?
Please.
I might have missed something, but besides state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Take your time.
Yeah, all I heard is going somewhere. It doesn't say he was driving anywhere.
I'm not sure, Your Honor, there was anything additional.
Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but.
So it doesn't match with my client.
Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said the RAV4 belonged to his mother.
What looked like a routine DIWI case took an unexpected turn in court when the judge closely examined the evidence against Abraham Salas. Prosecutors claimed Salas crashed his vehicle, fled the scene, and showed signs of intoxication. But as the hearing unfolded, defense attorneys challenged a critical detail: whether there was actually enough proof that Salas had been driving the vehicle at all.
Martinez stated after a short time that Salas asked Martinez if he had papers referring to immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation still.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him. And
He said a Mexican driver swerved in front of him. Is that what he said?
I told him no Tango Papeles, or I don't have papers. Salas said the other driver was in a gray Toyota, telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink.
Yeah, I mean, I think if they,
He was operating the vehicle at the time of the accident.
and you have the other person say something, right?
They
That's all.
say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstances, that it was a driver. I don't know if the witness actually saw him driving, but we have to prove the driving facts is that Reeves fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. He was found nearby. Was observed coming out of the grass nearby. We can find him with a driver.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence, but don't kill anyone. Do you understand?
Yes, John.
See,
Thank you, Ron. Are there any conditions you're imposing on the evading case?
no, I'm going to find no on both.
The prosecution argued that Salas admitted he was driving before the crash and pointed to witness statements, his presence near the wrecked vehicle, and his attempt to flee from police. Officers also reported signs of alcohol impairment and alleged drug use. However, the defense focused on a key legal issue. No witness explicitly stated they saw Salas operating the vehicle. After reviewing the facts, the judge agreed that the evidence fell short of establishing probable cause. In a surprising ruling, the court dismissed both charges at this stage. Still, the judge issued a stern warning, reminding Salas that alcohol-related crashes claim lives every day and that prosecutors could reopen the case if new evidence emerges. The hearing ended with no probable cause found, but the judge's powerful message about the dangers of impaired driving left a lasting impression